Question 1. Market research demonstrates a growing interest in recreational shooting activities in South Australia. An applicant for a Class H firearms license states their primary purpose is for participation in organized shooting competitions. What is the most appropriate approach for the licensing authority to assess this applicant's suitability? Option A. Conduct a thorough review of the applicant's stated purpose, verifying their membership in relevant shooting clubs, confirming the legitimacy of the competitions they intend to participate in, and assessing their understanding of safe firearm handling and storage as mandated by South Australian law. Option B. Accept the applicant's statement at face value, assuming that participation in organized shooting competitions inherently signifies responsible firearm ownership and a genuine need for a Class H license. Option C. Grant the license based on the applicant's enthusiasm for recreational shooting, without requiring specific evidence of their involvement in organized competitions or detailed assessment of their knowledge of safe practices. Option D. Immediately deny the license application, assuming that any applicant expressing interest in competitive shooting poses an elevated risk due to the nature of the firearms involved in such activities. The correct answer is A. Conduct a thorough review of the applicant's stated purpose, verifying their membership in relevant shooting clubs, confirming the legitimacy of the competitions they intend to participate in, and assessing their understanding of safe firearm handling and storage as mandated by South Australian law. Explanation: this scenario is professionally challenging because it requires balancing the applicant's stated intent with the objective assessment of their suitability for a Class H firearms license in South Australia. The core challenge lies in discerning genuine intent from potential misrepresentation or a lack of understanding of the responsibilities associated with firearm ownership, particularly concerning the specific requirements for a Class H license, which often involves a higher degree of scrutiny due to the nature of the firearms. Careful judgment is required to ensure public safety without unduly penalizing legitimate applicants. The best professional approach involves a thorough and objective assessment of the applicant's stated purpose for acquiring a firearm, cross-referenced with all available information and evidence. This includes verifying the legitimacy of the stated purpose, assessing the applicant's understanding of safe storage and handling requirements, and confirming they meet all eligibility criteria as stipulated by the South Australian Firearms Act 2015 and associated regulations. This approach prioritizes adherence to the law and the principle of public safety by ensuring that only individuals who can demonstrate a genuine, lawful, and responsible need for a firearm, and who understand the associated obligations, are granted a license. It aligns with the regulatory framework's intent to prevent firearms from falling into the wrong hands. An incorrect approach would be to solely rely on the applicant's verbal assurance without independent verification. This fails to meet the due diligence expected of licensing authorities and could lead to a license being granted to someone who does not genuinely meet the criteria or understand the responsibilities, thereby compromising public safety and contravening the spirit and letter of the Firearms Act 2015. Another incorrect approach involves making assumptions about the applicant's intent based on their demographic profile or perceived social standing. Such assumptions are discriminatory, subjective, and lack any basis in the regulatory requirements for a firearms license in South Australia. This approach undermines the principle of objective assessment and can lead to unfair outcomes. A further incorrect approach would be to grant the license based on a superficial review of the application, without delving into the specifics of the stated purpose or verifying supporting documentation. This demonstrates a lack of diligence and a failure to adequately assess the applicant's suitability, potentially overlooking critical red flags that would otherwise disqualify them. Professionals should employ a structured decision-making process that begins with a comprehensive understanding of the relevant legislation and policy. This involves systematically evaluating each criterion for license eligibility, seeking corroborating evidence for all claims made by the applicant, and maintaining an objective stance throughout the assessment. If any doubts or inconsistencies arise, further investigation or requests for additional information are warranted before a decision is made. Question 2. Quality control measures reveal that a South Australian applicant for a Class H firearms license has provided a completed application form stating a genuine reason for possessing a firearm as participation in competitive shooting. However, The application lacks specific details regarding their membership in an approved shooting club and evidence of completing a recognized firearms safety course. Which of the following approaches best addresses this situation in accordance with South Australian firearms legislation? Option A. Recommending the license be denied due to the incomplete information, without providing the applicant an opportunity to rectify the omissions. Option B. Proceeding with the license assessment by focusing solely on the applicant's personal character references, deeming them sufficient to override the missing documentation. Option C. Requesting the applicant to provide formal documentation confirming their membership in an approved shooting club and a certificate of completion for a recognized firearms safety course, as these are statutory requirements for a Class H license in South Australia. Option D. Approving the license based on the applicant's stated intention to participate in competitive shooting, assuming they will obtain the necessary club membership and complete the course at a later date. The correct answer is C. Requesting the applicant to provide formal documentation confirming their membership in an approved shooting club and a certificate of completion for a recognized firearms safety course, as these are statutory requirements for a Class H license in South Australia. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to demonstrate a thorough understanding of the legal and ethical responsibilities associated with firearm ownership in South Australia, specifically for a Class H license. The challenge lies in accurately assessing the applicant's suitability, which involves not just their stated intentions, but also their capacity to adhere to strict safety protocols and legal requirements. A failure to properly assess these aspects could have severe consequences, including the potential misuse of a firearm, endangering the public, and contravening the Firearms Act 1977. Correct approach analysis. The best professional approach involves a comprehensive review of the applicant's submitted documentation, cross-referencing it with the requirements outlined in the Firearms Act 1977 and associated regulations. This includes verifying the genuine reason for possessing a firearm, as defined by the Act, confirming the applicant's eligibility criteria, such as age, mental and physical fitness, and absence of disqualifying criminal convictions, and ensuring they have completed the required safety training. This approach is correct because it directly addresses the statutory requirements for licensing, prioritizing public safety and responsible firearm ownership as mandated by South Australian law. It ensures that all legal prerequisites are met before any recommendation for license approval is made. Incorrect approaches analysis. One incorrect approach involves solely relying on the applicant's stated intention to use the firearm for sport shooting, without independently verifying their membership in an approved shooting club or their completion of a recognized firearms safety course. This fails to meet the evidentiary requirements stipulated by the Firearms Act 1977 for establishing a genuine reason and demonstrating competence. Another incorrect approach is to approve the license based on the applicant's assurance that they will store the firearm securely, without confirming they have the appropriate safe storage facilities as mandated by the regulations. This overlooks the critical legal obligation to ensure safe storage, which is a cornerstone of firearms safety legislation in South Australia. A further incorrect approach is to overlook minor discrepancies in the application form, such as incomplete personal details or a lack of clarity regarding previous firearm ownership history, assuming they are not significant. This demonstrates a lack of due diligence and a failure to adhere to the thoroughness required by the licensing authority, potentially allowing an unsuitable individual to obtain a license. Professional reasoning. Professionals assessing firearm license applications in South Australia must adopt a systematic and evidence-based approach. This involves meticulously examining all submitted documentation against the specific provisions of the Firearms Act 1977 and its regulations. Key considerations include verifying the genuine reason for possession, confirming the applicant's suitability through background checks and medical assessments, and ensuring compliance with all storage and safety requirements. Any doubts or ambiguities should be clarified through further inquiry or by requesting additional documentation before making a recommendation. This rigorous process safeguards public safety and upholds the integrity of the firearms licensing system. Question 3. The audit findings indicate that a recent applicant for Class H firearms license in South Australia has disclosed a history of domestic disputes although no formal charges were laid. What is the most appropriate course of action for the licensing officer to take to ensure compliance with South Australian firearms legislation and uphold public safety? Option A. Approve the firearms license with only standard safety course conditions, without further investigation into the disputes. Option B. Reject the application outright due to the mention of domestic disputes, without further inquiry. Option C. Conduct a thorough investigation into the nature and context of the domestic disputes, seeking further information from the applicant and relevant sources, and objectively assess this against the suitability criteria in the Firearms Act 2015. Option D. Immediately approve the firearms license, as the applicant has stated a genuine reason, and no formal charges exist. The correct answer is C. Conduct a thorough investigation into the nature and context of the domestic disputes, seeking further information from the applicant and relevant sources, and objectively assess this against the suitability criteria in the Firearms Act 2015. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the applicant's stated need for a firearm with the paramount public safety obligations of the licensing authority in South Australia. The applicant's history of domestic disputes, even if not resulting in formal charges, raises a significant red flag regarding their temperament and potential risk of misuse. A licensing officer must exercise careful judgment to avoid both unduly restricting lawful firearm ownership and compromising community safety. Correct approach analysis. The best professional practice involves a thorough, documented assessment of the applicant's suitability, directly addressing the concerns raised by the domestic dispute history. This approach involves requesting further information from the applicant, potentially including statements from individuals involved in the disputes with consent, and consulting relevant databases or authorities for any undisclosed information. The officer must then objectively evaluate this information against the criteria outlined in the South Australian Firearms Act 2015 and associated regulations, particularly those pertaining to good character, mental stability, and the genuine reason for possessing a firearm. This rigorous, evidence-based approach ensures compliance with the Act's intent to protect public safety while fairly assessing the applicant. Incorrect approach is analysis. One incorrect approach involves immediately approving the license based solely on the applicant's assertion of a genuine reason and the absence of formal charges. This fails to adequately assess the risk posed by the domestic disputes, potentially contravening the licensing authority's duty to ensure firearms are not issued to individuals who may pose a danger. It neglects the spirit of the legislation, which requires a comprehensive assessment of suitability beyond mere absence of criminal convictions. Another incorrect approach is to summarily reject the application without further investigation. While caution is warranted, a complete denial without exploring the context and nature of the disputes or allowing the applicant an opportunity to provide mitigating information could be seen as procedurally unfair and may not align with the legislative framework's emphasis on a balanced assessment. A further incorrect approach is to approve the license with minimal conditions, such as a standard safety course, without specifically addressing the concerns arising from the domestic disputes. This approach fails to implement targeted risk mitigation strategies that might be necessary given the applicant's history, thereby potentially undermining public safety. Professional reasoning. Professionals in this role must adopt a structured decision-making process. This begins with identifying potential risks and concerns, such as the domestic disputes. Next, they must gather all relevant information, including applicant statements, third-party information, where permissible, and official records. This information is then critically evaluated against the specific legal requirements and policy guidelines of South Australia. Finally, a decision is made, with clear, documented reasons, that prioritizes public safety while adhering to principles of fairness and due process. Question 4. Strategic planning requires a thorough assessment of an applicant's suitability for a Class H firearms license in South Australia. Considering an applicant who has recently experienced significant financial stress and personal difficulties, which of the following approaches best reflects the necessary due diligence and regulatory compliance? Option A. Automatically deny the license application due to the applicant's recent financial difficulties, as this indicates a potential lack of responsibility. Option B. Focus solely on the applicant's stated genuine reason for possessing a firearm, disregarding any personal circumstances that may affect their judgment or ability to comply with regulations. Option C. Conduct a comprehensive review of the applicant's stated genuine reason, their history, and their current circumstances, with a specific focus on their capacity to comply with the storage and safety provisions mandated by the South Australian Firearms Act 2015. Option D. Accept the applicant's assurances regarding their ability to safely store firearms without further investigation, as their genuine reason for needing the license is clearly stated. The correct answer is C. Conduct a comprehensive review of the applicant's stated genuine reason, their history, and their current circumstances, with a specific focus on their capacity to comply with the storage and safety provisions mandated by the South Australian Firearms Act 2015. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to demonstrate not only a genuine reason for possessing a firearm, but also an understanding of their ongoing responsibilities and the potential impact of their circumstances on their license eligibility. The South Australian Firearms Act 2015 and associated regulations place a significant onus on applicants to prove they are fit and proper persons to hold a license, which includes assessing their capacity to store firearms safely and responsibly, and to not pose a risk to themselves or others. The applicant's recent financial difficulties and associated stress, while understandable, raise questions about their current stability and ability to adhere to strict storage and handling requirements, necessitating a thorough and objective assessment by the licensing authority. Correct approach analysis. The best professional approach involves a comprehensive review of the applicant's stated genuine reason, their history, and their current circumstances, with a specific focus on their capacity to comply with the storage and safety provisions mandated by the South Australian Firearms Act 2015. This includes a detailed assessment of their proposed firearm storage arrangements and their mental and emotional state, ensuring they can meet the stringent requirements for safe and responsible firearm ownership. The licensing authority must consider whether the applicant's current situation presents any contravention of the Act's provisions regarding suitability, particularly concerning the risk of misuse or negligent storage. This approach aligns with the Act's objective of public safety by ensuring only responsible individuals are granted firearm licenses. Incorrect approach is analysis. An approach that focuses solely on the applicant's stated genuine reason without adequately investigating their current financial and emotional stability would be professionally unacceptable. This fails to address the potential risks associated with an individual under significant stress, who may not be able to maintain the required standards of firearm security and responsible handling, potentially contravening the fit and proper person provisions of the Act. Another professionally unacceptable approach would be to automatically deny the license based on the applicant's financial difficulties alone, without a thorough assessment of their specific circumstances and their ability to meet all license conditions. This could be seen as discriminatory and fails to consider that financial hardship does not inherently disqualify an individual from responsible firearm ownership, provided they can demonstrate compliance with all safety and storage requirements. Finally, an approach that prioritizes administrative expediency over a thorough risk assessment, such as accepting the applicant's assurances without verifying their proposed storage arrangements or considering the impact of their stress on their judgment, would be a significant regulatory failure. This overlooks the critical importance of robust safety measures and the licensing authority's duty to ensure public safety, as outlined in the Firearms Act 2015. Professional reasoning. Professionals in this field must adopt a balanced approach that upholds public safety while ensuring fair and objective assessment of applicants. This involves a systematic process of gathering information, assessing risks against regulatory requirements, and making decisions based on evidence and the spirit of the law. When faced with complex personal circumstances, professionals should 1. Clearly identify the relevant legislative requirements, e.g., South Australian Firearms Act 2015, genuine reason, fit and proper person, storage requirements. 2. Objectively evaluate how the applicant's current situation impacts their ability to meet these requirements. 3. Seek further information or clarification where necessary. 4. Document the decision-making process thoroughly, justifying the outcome based on the evidence and regulatory framework. Question 5. The performance metrics show a consistent increase in firearms license applications in South Australia. An applicant for a Class H license has disclosed a history of domestic disputes with a former partner over the past 2 years, though no charges were ever laid by police. The applicant states these disputes are now fully resolved and they have no intention of misusing a firearm. As the assessing officer, what is the most appropriate course of action to ensure compliance with South Australian firearms legislation? Option A. Deny the license application solely based on the mention of domestic disputes, as any history of such incidents automatically disqualifies an applicant. Option B. Grant the license immediately, as the applicant has stated the disputes are resolved and no charges were laid, indicating no legal impediment. Option C. Conduct a comprehensive assessment of the applicant's suitability, including a detailed interview to explore the nature of the domestic disputes and their current mental state, and consult relevant records to determine if the applicant poses an unacceptable risk to public safety. Option D. Dismiss the domestic dispute history as irrelevant to the license application, as it did not result in criminal charges. The correct answer is C. Conduct a comprehensive assessment of the applicant's suitability, including a detailed interview to explore the nature of the domestic disputes and their current mental state, and consult relevant records to determine if the applicant poses an unacceptable risk to public safety. Explanation. This scenario presents a professional challenge because it requires balancing the applicant's stated intent for firearm ownership with the paramount public safety obligations mandated by South Australian firearms legislation. The applicant's history of domestic disputes, even if not resulting in formal charges, raises a significant red flag concerning their suitability to possess a firearm, as it indicates potential issues with impulse control or conflict resolution that could pose a risk to themselves or others. Careful judgment is required to assess this risk objectively and in accordance with the law. The best approach involves a thorough, objective assessment of the applicant's suitability, prioritizing public safety and adherence to the Firearms Act 2015 SA and its associated regulations. This includes a comprehensive review of all provided documentation, a detailed interview to probe the circumstances of the domestic disputes and the applicant's current mental state, and consultation with relevant authorities or professionals, if deemed necessary, to form a well-reasoned opinion on whether the applicant poses an unacceptable risk. This approach directly addresses the core requirement of the licensing authority to determine if the applicant is a fit and proper person to hold a license, as stipulated by Section 12 of the Firearms Act 2015 SA, which mandates consideration of factors that might indicate a risk to public safety. An incorrect approach would be to dismiss the domestic disputes as irrelevant simply because no charges were laid. This fails to acknowledge that the Firearms Act 2015 SA requires an assessment of suitability beyond mere criminal convictions. The law empowers the licensing authority to consider any information that suggests an applicant might be a risk, and a pattern of domestic disputes, even without formal charges, can be indicative of such a risk. Another incorrect approach is to grant the license based solely on the applicant's assurance that the disputes are resolved, and that they have no current intention to misuse the firearm. This approach is overly reliant on the applicant's self-reporting and neglects the licensing authority's duty to conduct an independent and rigorous assessment of risk. It bypasses the due diligence required to ensure public safety. Finally, an incorrect approach would be to deny the license outright based on the mere mention of domestic disputes without a proper investigation or assessment. While public safety is paramount, the licensing authority must also act fairly and consider all relevant information. A blanket denial without a thorough evaluation of the specific circumstances and the applicant's current situation would be procedurally unfair and potentially unlawful. The professional reasoning process for such situation should involve a structured risk assessment framework. This framework should include identifying potential risk factors, e.g., history of violence, mental health concerns, substance abuse, gathering all available information, documentation, interviews, external checks, objectively evaluating the severity and recency of risk factors, considering mitigating factors, and making a decision based on whether the applicant meets the legal threshold of being a fit and proper person to hold a firearms license, with a clear justification for the decision, grounded in the Firearms Act 2015 SA. Question 6. Stakeholder feedback indicates a concern regarding the thoroughness of impact assessments for Class H firearms license applications in South Australia. An applicant for a Class H license in South Australia has declared no criminal convictions or apprehended violence orders. However, police records reveal multiple documented instances of domestic disputes involving the applicant over the past 5 years, none of which resulted in formal charges being laid. The applicant states their sole purpose for seeking the license is for recreational target shooting. Considering the regulatory framework governing firearms licensing in South Australia, which approach to assessing this applicant's suitability is most professionally sound and compliant with the Firearms Act 2015. Option A. Issue the license. Assuming the applicant's stated lawful purpose for recreational target shooting negates any potential risk suggested by past disputes. Option B. Conduct a comprehensive risk assessment that actively investigates the documented domestic disputes and their potential implications for public safety, alongside verifying the applicant's stated lawful purpose. Option C. Dismiss the domestic dispute information as irrelevant to the license application because no formal charges were laid by the police. Option D. Grant the license based on the absence of criminal convictions and apprehended violence order, as these are the primary disqualifying factors explicitly listed in the legislation. The correct answer is B. Conduct a comprehensive risk assessment that actively investigates the documented domestic disputes and their potential implications for public safety, alongside verifying the applicant's stated lawful purpose. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the applicant's stated intent for firearm ownership with the paramount public safety obligations mandated by South Australian firearms legislation. The applicant's history of domestic disputes, even if not resulting in formal charges, raises a significant red flag regarding their suitability and potential risk to themselves or others. A thorough impact assessment must consider not only the direct regulatory requirements, but also the broader ethical implications of licensing an individual who may pose a heightened risk. Careful judgment is required to avoid both unduly restricting lawful ownership and compromising public safety. Correct approach analysis. The best professional practice involves conducting a comprehensive risk assessment that goes beyond a simple check of formal convictions. This approach involves actively seeking and evaluating information that indicates potential unsuitability, such as documented domestic disputes, even if they did not lead to charges. The Firearms Act 2015, South Australia, and associated regulations place a strong emphasis on the applicant's character, propensity for violence, and overall suitability to possess a firearm. A thorough impact assessment, as outlined in this approach, directly addresses these concerns by investigating the applicant's history of interpersonal conflict and its potential implications for public safety, aligning with the Act's intent to prevent firearms from falling into the wrong hands. Incorrect approaches analysis. One incorrect approach involves solely relying on the absence of formal criminal convictions or apprehended violence orders. This fails to meet the spirit and intent of the Firearms Act 2015, South Australia, which requires a broader assessment of an applicant's suitability. The Act implicitly requires consideration of factors that might indicate a propensity for violence or a lack of judgment, even if not formally adjudicated. Ignoring documented domestic disputes, even without charges, represents a failure to conduct a sufficiently thorough impact assessment and could lead to licensing an individual who poses an unacceptable risk. Another incorrect approach is to dismiss the domestic dispute information as irrelevant because no charges were laid. This overlooks the potential for escalating conflict and the inherent risks associated with firearms. The regulatory framework in South Australia expects licensing authorities to exercise due diligence and consider all available information that might bear on an applicant's suitability. A superficial review that disregards potentially significant behavioral indicators is a dereliction of this duty. A third incorrect approach is to grant the license based solely on the applicant's stated lawful purpose for owning the firearm, without adequately investigating the potential risks highlighted by their history. While a lawful purpose is a necessary condition, it is not sufficient on its own. The impact assessment must weigh the stated purpose against any identified risks to public safety, ensuring that the applicant's character and history do not contradict the presumption of suitability. Professional reasoning. Professionals in this field must adopt a proactive and risk-averse approach. The decision-making process should involve a multifaceted impact assessment that considers all available information, not just formal records. This includes scrutinizing the applicant's history for any indicators of potential unsuitability, such as interpersonal conflicts, mental health concerns, or substance abuse issues, even if they haven't resulted in legal sanctions. The primary objective is to uphold public safety by ensuring that only individuals of sound character and judgment are granted firearm licenses. When in doubt, further investigation or consultation with relevant authorities is warranted. Question 7. Regulatory review indicates that an applicant for Class H firearms license in South Australia has a history of reported domestic disputes, though no formal charges were laid or convictions recorded. What is the most appropriate course of action for the licensing authority to take in assessing this applicant's suitability? Option A. Conduct a comprehensive review of the domestic dispute reports. Seek further information from the applicant and relevant parties where permissible, and assess the applicant's overall suitability against the criteria in the Firearms Act 1979, South Australia, focusing on public safety. Option B. Grant the license without further investigation, assuming that the lack of formal charges signifies no risk to public safety. Option C. Base the decision on informal discussions with individuals who may have knowledge of the applicant's past behavior without formal documentation. Option D. Automatically deny the license application due to the presence of domestic dispute reports, irrespective of the absence of formal charges. The correct answer is A. Conduct a comprehensive review of the domestic dispute reports, seek further information from the applicant and relevant parties where permissible, and assess the applicant's overall suitability against the criteria in the Firearms Act 1979, South Australia, focusing on public safety. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent responsibility associated with firearms licensing. The applicant's history of domestic disputes, even if not resulting in formal charges, raises significant concerns regarding their suitability to possess a firearm. The licensing authority must balance the applicant's right to apply with the paramount public safety imperative. Careful judgment is required to assess the risk posed by the applicant without resorting to arbitrary denial. Correct approach analysis. The best professional practice involves a thorough, objective, and documented assessment of the applicant's suitability, considering all available information. This includes a detailed review of the domestic dispute reports, seeking further clarification from the applicant, and potentially consulting with relevant authorities or professionals, if permitted by law and deemed necessary, for a comprehensive risk evaluation. The focus must remain on whether the applicant meets the criteria for a Class H license under the Firearms Act 1979, South Australia, specifically concerning their propensity for violence or any risk to public safety. This approach ensures a fair and legally defensible decision based on evidence and statutory requirements. Incorrect approaches analysis. One incorrect approach is to automatically deny the license solely based on the existence of domestic dispute reports, regardless of whether formal charges were laid or convictions obtained. This fails to adhere to the principle of assessing individual suitability and may be considered an arbitrary denial, potentially contravening principles of natural justice and the specific provisions of the Firearms Act 1979, South Australia, which require consideration of the applicant's character and suitability. Another incorrect approach is to grant the license without any further investigation into the domestic dispute reports, assuming that the absence of formal charges equates to no risk. This neglects the licensing authority's duty of care to protect the public and fails to conduct a proper impact assessment of potential risks, thereby potentially contravening the spirit and intent of the firearms licensing legislation in South Australia. A further incorrect approach is to rely on anecdotal information or personal biases when evaluating the applicant's suitability. Decisions must be based on objective evidence and statutory criteria, not on subjective opinions or unsubstantiated rumors, which would undermine the integrity of the licensing process and expose the authority to legal challenge. Professional reasoning. Professionals in this field must adopt a systematic and evidence-based decision-making process. This involves 1. Understanding the relevant legislation, e.g., Firearms Act 1979, South Australia, and associated regulations. 2. Objectively gathering all pertinent information. 3. Conducting a thorough risk assessment, considering the potential impact on public safety. 4. Documenting all steps taken and the rationale for the decision. 5. Ensuring the decision is fair, transparent, and legally sound. Question 8. Performance analysis shows that a South Australian Class H firearms license applicant has provided a medical certificate stating they are fit to hold a firearms license, but also disclosed a history of a significant mental health condition treated 5 years ago. What is the most appropriate next step for the licensing authority in South Australia? Option A. Accept the medical certificate at face value and proceed with the license application without further investigation. Option B. Conduct a detailed interview with the applicant and seek specific clarification from their treating medical practitioner regarding their current mental state and capacity to safely possess a firearm. Option C. Approve the license based on the medical certificate and a brief, general conversation with the applicant about firearm safety. Option D. Automatically reject the application due to the applicant's past mental health diagnosis, regardless of the medical certificate or current circumstances. The correct answer is B. Conduct a detailed interview with the applicant and seek specific clarification from their treating medical practitioner regarding their current mental state and capacity to safely possess a firearm. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with firearms and the strict legal framework governing their possession and use in South Australia. The applicant's history of mental health concerns, even if seemingly resolved, requires a thorough and cautious assessment to ensure public safety and compliance with the Firearms Act 1977 SA and associated regulations. The core challenge lies in balancing the applicant's right to apply for a license with the paramount responsibility of the licensing authority to prevent firearms from falling into the wrong hands. This necessitates a deep understanding of the assessment criteria and the potential implications of any oversight. Correct approach analysis. The best professional practice involves a comprehensive review of all provided documentation, including the medical certificate, and a direct, detailed interview with the applicant. This approach ensures that the licensing authority has a complete picture of the applicant's current mental state and the nature of their past condition. Specifically, it requires seeking clarification from the treating medical practitioner regarding the applicant's current fitness to possess a firearm, as mandated by the Firearms Act 1977 SA and the Firearms Regulations 2017 SA, which place a strong emphasis on the applicant's mental and physical capacity. This proactive engagement with medical professionals and the applicant directly addresses the core concerns of the legislation, which prioritizes public safety by ensuring that only individuals of sound mind and responsible character are granted firearms licenses. Incorrect approaches analysis. One incorrect approach involves solely relying on the provided medical certificate without further inquiry, even if it states the applicant is fit. This is insufficient because medical certificates can be general, and the specific context of firearms possession requires a more detailed assessment of the applicant's capacity to exercise the necessary judgment and control. Legislation implies a duty to investigate further when there are known past issues that could potentially impact current fitness. Another incorrect approach is to automatically reject the application based on the past mental health diagnosis alone, without considering the applicant's current circumstances and medical advice. This fails to acknowledge that mental health conditions can be managed and treated, and a blanket rejection would be discriminatory and not in line with a fair assessment process that considers rehabilitation and current fitness. The law requires an assessment of current fitness, not just a historical record. A further incorrect approach is to approve the license based on a brief, superficial interview that does not delve into the specifics of the past mental health episode or the applicant's current coping mechanisms and understanding of the responsibilities of firearm ownership. This approach bypasses the critical need for a thorough evaluation of the applicant's suitability and could lead to a dangerous outcome, failing the primary objective of the licensing process. Professional reasoning. Professionals in this field must adopt a risk-based, evidence-driven decision-making process. This involves 1. Thoroughly reviewing all submitted documentation, paying close attention to any disclosures or historical information that may indicate a risk. 2. actively seeking further information where necessary, particularly from medical professionals, to clarify any ambiguities or concerns. 3. Conducting detailed interviews with applicants to assess their understanding, maturity, and current fitness. 4. Applying the specific legislative requirements and guidelines of South Australia rigorously, always prioritizing public safety. 5. Documenting all steps taken and the rationale behind the final decision to ensure accountability and transparency. Question 9. The efficiency study reveals that a Class H firearms license applicant in South Australia is seeking to possess a handgun for competitive shooting. The applicant has provided a brief statement regarding their proposed storage arrangements. Which of the following approaches best demonstrates the applicant's understanding and compliance with the relevant South Australian firearms legislation regarding safe storage? Option A. The applicant states they will purchase a standard gun safe and store the handgun and ammunition together in a locked room within their residence. Option B. The applicant simply declares that they will ensure the firearm is stored safely and securely as required by law. Option C. The applicant provides a detailed description of the proposed firearm safe, including its specifications, locking mechanism, installation method, and a separate, secure storage plan for ammunition, all in accordance with the Firearms Act 2015, SA, and Firearms Regulations 2017, SA. Option D. The applicant mentions they have a secure cabinet for their hunting rifles and will adapt it to store the handgun and ammunition. The correct answer is C. The applicant provides a detailed description of the proposed firearm safe, including its specifications, locking mechanism, installation method, and a separate, secure storage plan for ammunition, all in accordance with the Firearms Act 2015 SA and Firearms Regulations 2017 SA. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to demonstrate not only a genuine reason for possessing a firearm, but also the capacity to store it securely, directly impacting public safety. The onus is on the applicant to satisfy the South Australian Police that their proposed storage arrangements meet the stringent requirements of the Firearms Act 2015, SA, and associated regulations, which are designed to prevent unauthorized access and misuse. A failure to adequately assess and communicate these arrangements can lead to license refusal, even if the reason for possession is valid. Correct approach analysis. The best professional practice involves the applicant proactively and comprehensively detailing their proposed firearm storage arrangements, including specific details about the type of safe, its location, locking mechanisms, and any security measures for the ammunition. This approach directly addresses the core requirements of the Firearms Act 2015 SA and the Firearms Regulations 2017 SA concerning safe storage. By providing detailed, verifiable information, the applicant demonstrates a clear understanding of their legal obligations and a commitment to responsible firearm ownership, thereby satisfying the licensing authorities' concerns regarding public safety and preventing unauthorized access. This aligns with the principle that applicants must prove they are fit and proper persons to hold a license, which includes demonstrating adequate security measures. Incorrect approach is analysis. Proposing vague or generic storage solutions, such as simply stating, "I will store it in a safe," fails to meet the detailed requirements of the legislation. The South Australian Police need specific information to assess compliance, and a general statement provides no assurance of adequate security. This approach risks being perceived as a lack of understanding or commitment to safe storage obligations, suggesting storage in a location that is not inherently secure or easily accessible to unauthorized persons, even if a safe is mentioned, directly contravenes the spirit and letter of the Firearms Act 2015 SA. The Act mandates secure storage to prevent theft or access by prohibited persons, failing to mention any specific security measures for ammunition, or proposing to store ammunition with the firearm in a manner that does not meet regulatory standards, is a significant oversight. The regulations often require separate secure storage for ammunition, or specific conditions for combined storage to further mitigate risks. Professional reasoning. Professionals assessing firearm license applications must adopt a systematic approach. This involves 1. Thoroughly understanding the applicant's stated genuine reason for possessing the firearm. 2. Critically evaluating the proposed storage arrangements against the specific requirements of the Firearms Act 2015 SA and the Firearms Regulations 2017 SA. This includes scrutinizing details of the safe, its installation, locking mechanisms, and ammunition storage. 3. Identifying any gaps or ambiguities in the applicant's submission and seeking clarification or further evidence. 4. Making a determination based on whether the applicant has demonstrably met all legal requirements and has provided sufficient evidence to satisfy the licensing authority of their suitability and commitment to safe firearm management. Question 10. The monitoring system demonstrates that a South Australian Class H firearms license holder, whose current license expires on 31 December 2024, has applied for renewal on 1 September 2024. The annual renewal fee for a Class H license, as stipulated by the Firearms Act 1977, South Australia, and its regulations, is $150. If the renewal is processed on 1 September 2024 and the new license term will commence immediately upon expiry of the current one, what is the correct fee payable for this early renewal, assuming the renewal fee is calculated on a pro rata basis for the period extending beyond the current license expiry? Option A, $137.50. Option B, $112.50. Option C, $125.00. Option D, $150.00. The correct answer is B, $112.50. Explanation. This scenario is professionally challenging because it requires the accurate calculation of license renewal fees based on specific legislative provisions, while also considering potential administrative errors. A firearms license holder's responsibility extends to ensuring their license is renewed correctly and on time, which includes understanding the associated costs as stipulated by the relevant South Australian legislation. Miscalculation or misapplication of fee structures can lead to non-compliance, potential penalties, and administrative complications for both the licensee and the issuing authority. The best professional approach involves a meticulous review of the Firearms Act 1977, South Australia, and its associated regulation, specifically focusing on the fee schedule for Class H licenses and any applicable pro rata adjustments for early renewal. This approach ensures adherence to the legal framework governing firearms licensing in South Australia. The calculation should be performed by directly applying the prescribed annual fee and then determining the pro rata amount based on the remaining period of the current license term, as per the legislative guidelines. This method is correct because it directly reflects the statutory requirements for license renewal fees, ensuring the licensee pays the exact amount mandated by law. An incorrect approach would be to simply apply the full annual renewal fee without considering the pro rata adjustment for early renewal. This fails to adhere to the specific fee calculation methods outlined in the regulations, potentially leading to an overpayment by the licensee and a deviation from the legally prescribed fee structure. Another incorrect approach would be to estimate the fee based on previous renewals or general knowledge of fee increases. This is professionally unacceptable as it relies on assumptions rather than the definitive legislative framework, risking underpayment or overpayment and thus non-compliance. Finally, assuming the fee remains constant year on year without consulting the current regulations is also an incorrect and unprofessional approach, as fee structures are subject to legislative updates and changes. Professionals should adopt a decision-making process that prioritizes consulting the most current and authoritative legal sources. This involves identifying the specific legislative provisions related to firearms license fees, understanding the calculation methodology, including any pro rata provisions, performing the calculation accurately, and then verifying the result against the official fee schedule or by seeking clarification from the relevant South Australian authority. Question 11. The control framework reveals that an applicant for a Class H firearms license in South Australia has a documented history of domestic disputes, though no formal charges were ever laid. Considering the requirements of the Firearms Act 1977, SA, which of the following represents the most appropriate course of action for the licensing authority? Option A. Automatically deny the firearms license application due to the presence of domestic disputes in the applicant's history, regardless of the absence of formal charges. Option B. Issue the firearms license with a condition that the applicant must attend anger management counseling without conducting a detailed review of the disputes themselves. Option C. Conduct a thorough investigation into the nature and circumstances of the domestic disputes, reviewing any available police records, court documents, and seeking further information from the applicant and potentially other relevant parties to determine if the applicant meets the fit and proper person criteria. Option D. Grant the firearms license without further inquiry, assuming that the absence of formal charges indicates the disputes are not relevant to the applicant's suitability. The correct answer is C. Conduct a thorough investigation into the nature and circumstances of the domestic disputes, reviewing any available police records, court documents, and seeking further information from the applicant and potentially other relevant parties to determine if the applicant meets the fit and proper person criteria. Explanation. The control framework reveals a scenario where an applicant for a Class H firearms license in South Australia has a history of domestic disputes. This presents a professionally challenging situation because the assessment of an applicant's suitability for a firearms license in South Australia requires a delicate balance between public safety and individual rights. The core challenge lies in interpreting the applicant's past behavior through the lens of the Firearms Act 1977, SAW, and associated regulations, specifically concerning the assessment of whether the applicant is a fit and proper person to possess a firearm. This involves scrutinizing any evidence that might indicate a propensity for violence or an inability to safely store and handle firearms. The decision-maker must avoid making assumptions, while also ensuring that potential risks are thoroughly investigated and addressed. The best approach involves a comprehensive review of all available information, including police reports, court records, and any statements from the applicant or relevant third parties, to determine if the domestic disputes demonstrate a pattern of behavior that would render the applicant unfit to hold a license under the fit and proper person provisions of the Firearms Act 1977 SAW. This approach is correct because it directly addresses the statutory requirement to assess the applicant's suitability by examining their history for indicators of risk. It prioritizes a thorough, evidence-based assessment, aligning with the ethical obligation to protect public safety while adhering to the legal framework that governs firearms licensing in South Australia. The focus is on objective evidence and its interpretation within the context of the Act's intent. An incorrect approach would be to automatically deny the license based solely on the mention of domestic disputes without further investigation. This fails to uphold the principle of procedural fairness and may be discriminatory, as not all domestic disputes automatically disqualify an individual. It bypasses the requirement for a nuanced assessment of the applicant's current circumstances and the nature of the past disputes. Another incorrect approach would be to grant the license without any specific conditions or further inquiry, assuming that past disputes are irrelevant if no formal charges were laid. This ignores the potential for underlying issues that could still pose a risk, even in the absence of criminal convictions. The fit and proper person test is broader than just criminal history and requires consideration of all relevant factors that might impact safe firearm ownership. A further incorrect approach would be to rely solely on the applicant's self-declaration that they have resolved all issues related to the disputes, without seeking independent verification or corroborating evidence. While self-declaration is part of the process, it cannot be the sole basis for a decision when significant safety concerns are indicated by the applicant's history. The professional reasoning process for similar situations should involve 1. Identifying the core statutory requirements, e.g., fit and proper person test. 2. Gathering all relevant information, including official records and applicant statements. 3. Analyzing the information objectively, considering the context and severity of any past incidents. 4. Applying the legal criteria to the gathered evidence, making a reasoned decision that prioritizes public safety while respecting procedural fairness. 5. Documenting the decision-making process thoroughly. Question 12. Market research demonstrates that applicants for a Class H firearms license in South Australia sometimes face dilemmas regarding the disclosure of past incidents. Considering the requirements of the Firearms Act 1977 SAW and the Firearms Regulations 2017 SAW, which of the following approaches best reflects professional and regulatory compliance when an applicant has had a minor domestic dispute that resulted in police attendance but no charges were laid? Option A. Fully disclose the incident, including the fact that police attended and the outcome, providing any relevant context. Option B. Only disclose the incident if specifically asked about domestic disputes by the registrar. Option C. Omit the incident from the application, assuming that since no charges were laid, it is not relevant. Option D. Briefly mention the incident without providing specific details about police attendance or the outcome. The correct answer is A. Fully disclose the incident, including the fact that police attended and the outcome, providing any relevant context. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to accurately and comprehensively disclose all relevant information regarding their past conduct, even if they believe it is minor or irrelevant to their current application for a Class H firearms license in South Australia. Failure to do so can lead to the license being refused or revoked, and potentially other penalties. The applicant's perception of the event's significance is subjective, whereas the licensing authority's assessment is based on objective criteria and the paramount importance of public safety. Careful judgment is required to ensure full transparency and compliance with the Firearms Act 1977, SA, and associated regulations. Correct approach analysis. The best professional practice involves the applicant providing a full and frank disclosure of the apprehended domestic violence incident, including details of the police involvement and the outcome, even if no charges were laid or conviction resulted. This approach aligns with the principles of honesty and integrity mandated by the Firearms Act 1977, SA, and the Firearms Regulations 2017, SA, particularly concerning the assessment of an applicant's suitability and trustworthiness. Section 11 of the Firearms Act 1977, SA, requires applicants to provide information that the registrar considers necessary to determine their suitability. Omitting or downplaying such an incident, regardless of the applicant's belief about its severity, constitutes a failure to provide complete information, which can be grounds for refusal. Transparency allows the registrar to make an informed decision based on all available facts, upholding the public interest in safe firearm ownership. Incorrect approach is analysis. One incorrect approach is to omit the incident entirely from the application, believing it was minor and did not result in charges. This is a significant regulatory failure, as it breaches the duty to provide complete and accurate information required by the Firearms Act 1977, SA. The registrar is entitled to know about any interactions with law enforcement, especially those involving allegations of violence, as these can be indicators of potential risk. Another incorrect approach is to only vaguely mention the incident without providing specific details about the police attendance and the outcome. This falls short of the full and frank disclosure expected and can be interpreted as an attempt to mislead the licensing authority. The Firearms Regulations 2017, SA, require sufficient detail for the registrar to assess the circumstances. A further incorrect approach is to assume that because no conviction occurred, the incident is irrelevant and does not need to be disclosed. The suitability assessment under the Firearms Act 1977, SA, is not solely based on convictions, but on a broader assessment of character, behavior, and any factors that might indicate a risk to public safety. Past incidents, even without a formal finding of guilt, can be relevant to this assessment. Professional reasoning. Professionals in this situation should adopt a framework of absolute transparency and proactive disclosure, and completing any application that requires disclosure of past events, especially those related to safety and suitability. The guiding principle should be to provide more information rather than less. If in doubt about whether an event needs to be disclosed, it is always safer and more professionally sound to disclose it and provide context. This approach minimizes the risk of regulatory breaches and demonstrates a commitment to ethical conduct and public safety, which are paramount in the firearms licensing process in South Australia. Question 13. When assessing an application for a Class H firearms license in South Australia, an applicant discloses a history of domestic disputes where police attended on multiple occasions, but no formal charges were ever laid. What is the most appropriate course of action for the licensing authority? Option A. Automatically refuse the license application due to the presence of domestic disputes, regardless of whether formal charges were laid, to prioritize public safety. Option B. Conduct a thorough investigation into the nature and circumstances of each domestic dispute, obtaining relevant police records and assessing the applicant's overall history to determine if they meet the fit and proper person criteria under the South Australia Firearms Act 2015. Option C. Accept the applicant's explanation that no charges were laid and therefore the incidents are not relevant to their suitability for a firearms license. Option D. Grant the license immediately, assuming that the absence of formal charges indicates the applicant is not a risk, and focus only on the applicant's stated intention for firearm use. The correct answer is B. Conduct a thorough investigation into the nature and circumstances of each domestic dispute, obtaining relevant police records, and assessing the applicant's overall history to determine if they meet the fit and proper person criteria under the South Australia Firearms Act 2015. Explanation. The assessment process reveals a scenario where an applicant for a Class H firearms license in South Australia has a history of domestic disputes, some of which involved police attendance, though no formal charges were laid. This presents a professionally challenging situation because the applicant's suitability for a firearms license is directly impacted by their capacity to safely and responsibly possess firearms, which is intrinsically linked to their personal conduct and history of conflict. The assessment requires a delicate balance between upholding public safety and respecting an individual's right to apply for a license, necessitating a thorough and objective evaluation of all relevant information. The correct approach involves a comprehensive review of the applicant's history, specifically focusing on the nature and frequency of the domestic disputes and the police involvement. This includes obtaining and scrutinizing police reports, the available court documents, even if no charges were laid, and potentially seeking further information from the applicant regarding these incidents. The primary regulatory framework governing this assessment is the South Australia Firearms Act 2015 and its associated regulations. Section 25 of the Act outlines the grounds for refusing a license, including if the applicant is deemed not to be a fit and proper person to hold a license, which encompasses considerations of public safety and the applicant's propensity for violence or conflict. A history of domestic disputes, even without convictions, can raise significant concerns about an applicant's temperament and their ability to safely handle firearms, especially if there is a pattern of escalating conflict or if the disputes involved threats or violence. Therefore, a thorough investigation into these matters is mandated by the need to ensure the applicant meets the fit and proper person criterion. An incorrect approach would be to dismiss the domestic disputes entirely because no formal charges were laid. This fails to acknowledge that the absence of charges does not equate to the absence of risk. Firearms Act requires an assessment of suitability, which goes beyond mere criminal convictions. Ignoring documented instances of domestic conflict, especially those involving police intervention, would be a regulatory failure as it bypasses a critical aspect of assessing an applicant's propensity for responsible firearm ownership. Another incorrect approach would be to automatically refuse the license solely based on the mention of domestic disputes, without a thorough investigation into the specifics of each incident. While public safety is paramount, a decision must be based on a comprehensive understanding of the facts, not on assumptions or broad generalizations. This would be an ethical failure, as it could unfairly penalize an individual without due process and a proper assessment of their current circumstances and overall suitability. A further incorrect approach would be to rely solely on the applicant's self-reported account of the domestic disputes without corroborating information. While the applicant's perspective is important, it must be balanced with objective evidence, such as police records, to ensure a complete and accurate assessment of their history and potential risks. The professional decision-making process for similar situations should involve a structured and objective risk assessment. This begins with identifying all relevant information, including the applicant's history, any reported incidents, and their current circumstances. The next step is to evaluate this information against the criteria set out in the Firearms Act 2015, particularly the fit and proper person requirement. This involves considering the nature, severity, frequency, and recency of any concerning behaviors. Professionals must then gather further information where necessary, such as requesting police reports or interviewing the applicant. Finally, a reasoned decision should be made, clearly articulating the justification based on the evidence and the relevant legislation, always prioritizing public safety. Question 14. Cost-benefit analysis shows that streamlining the firearms acquisition process can increase sales, but in South Australia, what is the most critical factor a Class H firearms dealer must verify when a customer presents a permit to acquire a handgun for sporting purposes? Option A. The customer's verbal confirmation that they are a licensed firearm owner and intend to use the handgun for sport. Option B. The customer's general eligibility for a firearms license, without specific verification of their current license status or genuine reason for this particular acquisition. Option C. The customer's current, valid Class H firearms license, confirmation of their stated genuine reason for acquisition, e.g., active participation in an approved pistol club, and the validity of the permit to acquire, ensuring all details align with the firearm being purchased. Option D. The customer's membership in any shooting club, regardless of whether it is an approved pistol club or if their license specifically permits handgun acquisition. The correct answer is C. The customer's current, valid Class H firearms license, confirmation of their stated genuine reason for acquisition, e.g., active participation in an approved pistol club, and the validity of the permit to acquire, ensuring all details align with the firearm being purchased. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in South Australia due to the strict regulatory environment surrounding firearms licensing and the ethical obligation to ensure public safety. The dealer must balance commercial interests with the paramount duty to comply with the Firearms Act 1974, SA, and its associated regulations, particularly concerning the verification of a customer's genuine reason for possessing a firearm and their eligibility. Misinterpreting or overlooking these requirements can lead to severe legal penalties, license suspension or cancellation, and contribute to the misuse of firearms. Correct approach analysis. The best professional practice involves a thorough and documented verification process that directly aligns with the requirements of the Firearms Act 1974, SA, and the specific conditions of a Class H license. This includes meticulously checking the applicant's current valid firearms license, confirming the stated genuine reason for acquisition, e.g., sporting shooter collector, against the license condition, and ensuring all required documentation, such as a current membership to an approved club or a permit to acquire, is presented and validated. This approach ensures compliance with Section 13 of the Firearms Act 1974, SA, which mandates that a dealer must not sell or transfer a firearm unless the buyer holds a valid license and a permit to acquire, and that the sale is consistent with the license holder's genuine reason. It also upholds the ethical duty of care to prevent firearms from falling into unauthorized hands. Incorrect approaches analysis. One incorrect approach involves accepting a verbal assurance from the customer about their genuine reason without seeking documentary evidence. This fails to meet the explicit requirements of the Firearms Act 1974 SA and its regulations, which necessitate verifiable proof of a genuine reason. Such a failure bypasses crucial checks designed to prevent the acquisition of firearms for illicit purposes. Another incorrect approach is to assume that because the customer possesses a firearms license, they are automatically eligible to acquire any type of firearm. This overlooks the specific restrictions and genuine reasons associated with different license classes, such as Class H, which has particular requirements for acquisition and possession. The Act requires verification that the specific firearm being acquired aligns with the license holder's approved genuine reason. A further incorrect approach is to prioritize the sale and only conduct a cursory review of the provided documentation, overlooking minor discrepancies or expired permits. This demonstrates a lack of due diligence and a failure to adhere to the spirit and letter of the law, which demands careful scrutiny to ensure all regulatory prerequisites are met before any transaction is completed. Professional reasoning. Professionals in this field should adopt a systematic checklist approach for every firearm transaction. This checklist should include verifying the validity and class of the customer's firearms license, confirming the genuine reason for acquisition against the license conditions and any supporting documentation, e.g., club membership, permit to acquire, and ensuring all details on the permit to acquire match the firearm and the buyer. Any discrepancies should be clarified and resolved before proceeding. This structured process, grounded in regulatory compliance and ethical responsibility, minimizes risk and upholds the integrity of the firearms licensing system in South Australia. Question 15. Operational review demonstrates that an applicant for a Class H firearms license in South Australia has provided a statement regarding their proposed storage of firearms and ammunition. Which of the following descriptions of the applicant's statement best reflects a comprehensive understanding and adherence to the South Australian regulatory framework for firearms safety? Option A. The applicant has detailed the specifications of an approved firearm safe, including its construction and locking mechanism, and confirmed that ammunition will be stored in a separate locked container, both located within their residence. Option B. The applicant has indicated that both firearms and ammunition will be stored in a locked safe, with no specific mention of separate storage for ammunition. Option C. The applicant has described their intention to store firearms in a locked cabinet and ammunition in a drawer, both within their residence, without specifying the type of cabinet or the security of the drawer. Option D. The applicant has stated that firearms will be stored unloaded in a locked container, and ammunition will be kept separately in a secure location within the home. Correct answer is A. The applicant has detailed the specifications of an approved firearm safe, including its construction and locking mechanism, and confirmed that ammunition will be stored in a separate locked container, both located within their residence. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the applicant to demonstrate a thorough understanding of the specific requirements for a Class H firearms license in South Australia, particularly concerning the storage of firearms and ammunition. Misinterpreting or failing to adhere to these regulations can lead to license refusal, potential safety risks, and legal repercussions. The applicant must navigate the nuances of the Firearms Act 1974 (SA) and its associated regulations, which are designed to ensure public safety and responsible firearm ownership. Correct approach analysis. The best approach involves the applicant accurately detailing their proposed firearm and ammunition storage arrangements, ensuring they explicitly comply with the minimum security standards mandated by the Firearms Act 1974 (SA) and the relevant regulations. This includes specifying the type of approved safe, its construction, locking mechanisms, and its location within the premises. Furthermore, it requires a clear statement that ammunition will be stored separately from firearms, also in a locked container, and in a manner that prevents unauthorized access. This approach directly addresses the core concerns of the licensing authority regarding safe and secure storage, demonstrating the applicant's commitment to responsible firearm ownership and compliance with the law. Incorrect approach is analysis. One incorrect approach involves the applicant providing a vague statement about storing firearms and ammunition securely without detailing the specific security measures or compliance with regulatory requirements. This fails to provide the licensing authority with the necessary assurance that the proposed storage meets the legal standards, potentially leading to license refusal due to insufficient information. Another incorrect approach is to claim that firearms and ammunition will be stored in a manner that does not explicitly meet the separate storage requirements for ammunition, or to propose storage that does not meet the minimum security specifications for a firearm safe as defined by the legislation. This directly contravenes the safety provisions of the Firearms Act 1974 (SA) and demonstrates a lack of understanding or disregard for the law, making the application unacceptable. A further incorrect approach would be to state that firearms will be stored unloaded and locked, but to omit any mention of ammunition storage, or to propose storing ammunition in the same unlocked container as the firearms. This demonstrates a critical misunderstanding of the dual requirements for safe firearm and ammunition storage, which are both essential for preventing unauthorized use and accidents. Professional reasoning. Professionals should approach such applications by meticulously reviewing the specific legislative requirements of the relevant jurisdiction. In this case, South Australia's Firearms Act 1974 and its regulations. They should then ensure that all information provided by the applicant directly addresses each of these requirements with verifiable details. A systematic checklist approach, cross-referencing the applicant's proposed arrangements against the legal obligations, is crucial for identifying any potential compliance gaps before submission. Question 16. The evaluation methodology shows that when assessing an applicant for a Class H firearms license in South Australia, and presented with a reference that is overly effusive and lacks specific examples of the applicant's responsible behavior, what is the most appropriate course of action? Option A. Accept the reference at face value, assuming the referee's positive sentiment indicates the applicant's suitability, and proceed with the license application. Option B. Immediately reject the application due to the vague nature of the reference, deeming it insufficient evidence of the applicant's character. Option C. Request the applicant to provide a new reference from someone with a more formal or professional relationship, without further investigation into the current reference. Option D. Seek additional, independent references and conduct further inquiries to corroborate the applicant's suitability and genuine reason, while acknowledging the provided references' limitations. The correct answer is D. Seek additional, independent references and conduct further inquiries to corroborate the applicant's suitability and genuine reason, while acknowledging the provided references' limitations. Explanation. The evaluation methodology shows that assessing an applicant's suitability for a Class H firearms license in South Australia requires a comprehensive understanding of their past behavior and potential risk. This scenario is professionally challenging because it involves balancing the applicant's right to apply with the paramount public safety imperative. The decision-maker must critically evaluate information that may be incomplete, subjective, or indicative of future risk, all within the strict confines of the Firearms Act 2015, SA, and associated regulations. Correct approach involves a thorough, objective, and documented assessment of all provided information against the criteria outlined in the Firearms Act 2015 SA, specifically focusing on the applicant's character, genuine reason for possessing a firearm, and any history that might indicate a propensity for misuse or danger. This includes scrutinizing references, verifying declared information, and considering any reported incidents or concerns. The regulatory justification lies in Section 14 of the Firearms Act 2015 SA, which mandates that the Commissioner must be satisfied that the applicant is a fit and proper person to hold a license and has a genuine reason. Ethical considerations demand impartiality and a commitment to public safety above all else. An incorrect approach would be to grant the license based solely on the applicant's assertion of a genuine reason, without independently verifying the supporting documentation or considering the implications of past, albeit minor, altercations. This fails to meet the fit and proper person test, as it overlooks potential indicators of poor judgment or a lack of respect for authority, which are critical for safe firearm ownership. Another incorrect approach is to deny the license summarily based on a single, unsubstantiated rumor or a past incident that has been fully addressed and resolved without any subsequent issues. This demonstrates a failure to conduct a balanced and fair assessment, potentially violating principles of natural justice and the applicant's right to have their current circumstances properly considered. The Act requires a holistic review, not a punitive stance based on outdated or unproven information. A further incorrect approach involves relying heavily on the subjective opinion of a referee without independently corroborating their statements or assessing their potential bias. While referees are important, their opinions must be weighed against other evidence and the applicant's overall profile. Over-reliance on a single, potentially biased, opinion can lead to an unfair decision and compromise the integrity of the licensing process. Professionals should employ a structured decision-making process that includes 1. Information gathering. Collect all relevant documentation, references, and any other information pertaining to the applicant. 2. Verification. Independently verify all submitted information, including genuine reasons and referee statements. 3. Risk assessment. Evaluate the gathered information against the fit and proper person criteria and genuine reason requirements as stipulated in the Firearms Act 2015 SA. Consider any red flags or areas requiring further investigation. 4. Documentation. Meticulously document all steps taken, information reviewed, and the rationale for the final decision. 5. Impartial decision. Make a decision based on the evidence and the law, free from personal bias or external pressure, always prioritizing public safety. Question 17. System analysis indicates that following the death of a Class H firearms license holder in South Australia, what is the most appropriate and legally compliant initial step for the executor of the deceased estate to take regarding the firearm, registered to the deceased? Option A. Attempt to sell the firearm privately to a friend who expresses interest, without involving official channels. Option B. Continue to store the firearm securely at the deceased's residence until beneficiaries decide on its future. Option C. Dispose of the firearm by dismantling it and discarding the parts in general household waste. Option D. Notify the South Australian Police Firearms Branch of the death and arrange for the firearm to be surrendered to a licensed dealer or police, or lawfully transferred to an eligible person. The correct answer is D. Notify the South Australian Police Firearms branch of the death and arrange for the firearm to be surrendered to a licensed dealer or police, or lawfully transferred to an eligible person. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in South Australia regarding the disposal of a firearm from a deceased estate. The core difficulty lies in navigating the specific legislative requirements for handling firearms when the license holder is no longer alive, ensuring compliance with the Firearms Act 2015, SA, and associated regulations, while also respecting the deceased's estate and the wishes of the beneficiaries. Failure to adhere to these provisions can result in significant penalties, including fines and license suspension or cancellation. Correct approach analysis. The best professional practice involves the executor or administrator of the deceased estate formally notifying the South Australian Police Firearms branch of the death and the existence of the firearm. They must then arrange for the firearm to be surrendered to a licensed dealer or police, or for its ownership to be lawfully transferred to an eligible person, all within the prescribed time frame. This approach is correct because it directly aligns with the requirements of the Firearms Act 2015, SA, particularly concerning the notification of death and the subsequent lawful disposal or transfer of firearms. Section 47 of the Act mandates that upon the death of a license holder, the executor or administrator must notify the registrar of firearms and ensure the firearm is dealt with in accordance with the Act, which includes surrender or transfer to an eligible person. This ensures public safety and prevents firearms from falling into unauthorized hands. Incorrect approaches analysis. One incorrect approach involves the executor simply storing the firearm indefinitely without any formal notification or arrangement for its disposal or transfer. This fails to comply with the statutory obligation to notify the authorities and arrange for lawful disposition, potentially leading to the firearm being unregistered or in the possession of an unauthorized person, which is a breach of the Firearms Act 2015 SA. Another incorrect approach is for the executor to attempt to sell the firearm privately to an individual without verifying the buyer's eligibility and without following the formal transfer procedures mandated by South Australian law. This bypasses the licensing and registration system, creating a significant risk of the firearm being acquired by someone who is not legally permitted to own it, and contravenes Section 48 of the Firearms Act 2015 SA regarding the transfer of firearms. A further incorrect approach would be for the executor to dispose of the firearm by discarding it or destroying it themselves without involving a licensed dealer or the police. This is not a recognized lawful method of disposal under the Firearms Act 2015 SA and could lead to the firearm being lost, stolen, or falling into the wrong hands, posing a serious public safety risk and violating the spirit and letter of the legislation. Professional reasoning. Professionals dealing with deceased estates and firearms in South Australia must adopt a proactive and compliant approach. The decision-making process should begin with identifying the presence of firearms and immediately consulting the Firearms Act 2015 SA and relevant police guidelines. The primary objective is to ensure the firearm is handled in a manner that is both legally compliant and prioritizes public safety. This involves clear communication with the executor, understanding their responsibilities, and guiding them through the correct notification and disposal or transfer processes. If there is any doubt about the legal requirements, seeking advice from the South Australian Police Firearms Branch or a legal professional specializing in firearms law is paramount. Question 18. Implementation of a firearms sale in South Australia for a Class H license holder. A dealer encounters a buyer whose stated purpose for acquiring the firearm is unusually vague and whose demeanor is slightly hesitant. What is the most professionally responsible course of action for the dealer to take? Option A. Proceed with the sale immediately as the buyer possesses a valid Class H license, assuming their stated purpose is legitimate. Option B. Thoroughly verify the buyer's Class H license details, seek clarification on the stated purpose for the firearm, and if concerns persist after inquiry, consider delaying the sale and reporting the situation to the South Australian Police. Option C. Refuse the sale outright due to the buyer's hesitant demeanor without further investigation into their stated purpose. Option D. Accept the buyer's vague explanation for the firearm's purpose without further questioning, as the license itself is the primary legal document. The correct answer is B. Thoroughly verify the buyer's Class H license details. Seek clarification on the stated purpose for the firearm, and if concerns persist after inquiry, consider delaying the sale and reporting the situation to the South Australian Police. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in South Australia regarding the sale of a Class H firearm. The challenge lies in balancing the legal requirements for sale with the ethical responsibility to ensure the firearm is not being acquired for illicit purposes, especially when a buyer exhibits unusual behavior or provides vague information. The dealer must navigate the specific provisions of the South Australian Firearms Act 1977 and associated regulations, which mandate thorough checks and record-keeping, while also exercising professional judgment to identify potential red flags. Failure to do so could result in legal penalties and compromise public safety. Correct approach analysis. The best professional practice involves a comprehensive verification process that goes beyond simply checking the buyer's license validity. This approach requires the dealer to meticulously review the buyer's application, cross-reference information with the provided license details, and critically assess the stated purpose for acquiring the firearm. If the stated purpose appears unusual or lacks sufficient detail, the dealer should proactively seek clarification, and if concerns persist, consider delaying or refusing the sale and reporting the situation to the relevant South Australian Police Authority, as per their obligations under the Act. This aligns with the spirit of the legislation, which aims to control the possession and use of firearms, and upholds the ethical duty of care expected of licensed dealers. Incorrect approach is analysis. One incorrect approach involves accepting the buyer's word at face value without further scrutiny, even if the license appears valid. This fails to meet the dealer's obligation to ensure the firearm is being acquired for a legitimate purpose as defined by South Australian law. The Firearms Act 1977 places a responsibility on dealers to be diligent in their sales process, not merely transactional. Another incorrect approach is to proceed with the sale solely based on the presence of a valid license, dismissing any unusual behavior or vague explanations as irrelevant. This overlooks the potential for license misuse or acquisition for prohibited purposes, which is a critical aspect of firearms regulation in South Australia. The law expects dealers to exercise a degree of professional skepticism when circumstances warrant it. A further incorrect approach is to refuse the sale immediately without attempting to gather more information or understand the buyer's stated purpose, especially if the buyer's behavior is merely slightly unconventional rather than overtly suspicious. While caution is necessary, an outright refusal without due diligence could be seen as discriminatory or an overreach if the buyer is genuinely compliant with all legal requirements. The dealer should aim to resolve ambiguities through professional inquiry before resorting to refusal. Professional reasoning. Professionals in this field should adopt a risk-based approach. This involves understanding the legal framework thoroughly, including the specific requirements for Class H firearms in South Australia. They should develop a checklist of verification steps that includes not only license validation, but also an assessment of the stated purpose and buyer behavior. When red flags are identified, a structured process of inquiry should be followed. If concerns remain unresolved after reasonable inquiry, the professional should consult internal policies, seek advice from regulatory bodies if necessary, and be prepared to document their decision-making process and any actions taken, including reporting to the authorities. The overarching principle is to uphold the law and public safety while treating customers fairly. Question 19. To address the challenge of ensuring lawful firearm transfers in South Australia, a firearms dealer is presented with a potential buyer who claims to possess a valid Class H firearms license. What is the most professionally responsible and legally compliant course of action for the dealer to take before completing the sale? Option A. Accept the buyer's presented license as proof of eligibility without further verification, assuming any Class H license permits the acquisition of any Class H firearm. Option B. Meticulously verify the buyer's South Australian Class H firearms license for currency and ensure the specific firearm is permitted under that license, completing all required transaction records. Option C. Complete the sale and transaction records, but defer the license verification process until a later date, relying on the buyer to provide updated information if necessary. Option D. Proceed with the sale based on the buyer's verbal assurance that their Class H license is current and allows for the purchase of the firearm. The correct answer is B. Meticulously verify the buyer's South Australian Class H firearms license for currency and ensure the specific firearm is permitted under that license, completing all required transaction records. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in South Australia due to the strict regulatory environment surrounding the licensing and sale of firearms. The core difficulty lies in balancing the business imperative to complete a sale with the absolute legal and ethical obligation to ensure all licensing requirements are met before transferring possession of a firearm. Failure to adhere to these regulations can result in severe penalties, including license suspension or cancellation, and significant legal repercussions. The dealer must exercise meticulous due diligence and a thorough understanding of the Firearms Act 1974 (SA) and associated regulations. Correct approach analysis. The best professional practice involves the dealer meticulously verifying the validity and appropriateness of the buyer's South Australian Class H firearms license. This includes confirming that the license is current, that the specific firearm being purchased is listed on the license, or that the license permits the acquisition of such a firearm, and that the buyer has completed the necessary permit to acquire process if applicable. The dealer must then record the transaction details accurately as required by South Australian law. This approach is correct because it directly aligns with the South Australian Firearms Act 1974 and its subordinate regulations, which place a clear onus on the seller to ensure the buyer is legally entitled to possess the firearm. This proactive verification process is the cornerstone of responsible firearm sales and upholds public safety. Incorrect approaches analysis. Proceeding with the sale based solely on the buyer presenting a license without verifying its current status or the specific firearm's eligibility for that license is a significant regulatory failure. This approach ignores the dealer's responsibility to actively confirm compliance, potentially leading to the transfer of a firearm to an unlicensed or improperly licensed individual. Relying on the buyer's assurance that their license is valid, or assuming that any Class H license automatically permits the acquisition of any Class H firearm, demonstrates a lack of due diligence and a disregard for the specific provisions of the Firearms Act 1974 (SA), which may stipulate conditions or specific firearm types. Furthermore, failing to complete the required transaction records as mandated by South Australian law constitutes a breach of record-keeping obligations, hindering law enforcement's ability to track firearm ownership and transfers. Professional reasoning. Professionals in this field must adopt a risk-averse and compliance-first mindset. The decision-making process should always begin with a thorough understanding of the relevant legislation. In this case, the South Australia Firearms Act 1974 and its regulations. When presented with a potential sale, the primary step is always to verify the buyer's legal entitlement to acquire and possess the specific firearm. This involves checking license validity, ensuring the firearm is permitted under that license, and completing all mandatory documentation. If any doubt exists, or if verification cannot be completed to the required standard, the sale must be postponed or refused until full compliance can be achieved. Ethical considerations, such as contributing to public safety by preventing firearms from falling into the wrong hands, are intrinsically linked to regulatory compliance. Question 20. The review process indicates a need to verify the accuracy of license fee calculations for a Class H firearms license holder in South Australia. The applicant has declared ownership of 2 handguns, Category A, and 1 rifle, Category B. According to the South Australian Firearms Regulations 2017, the annual license fee for Category A firearms is $50 per firearm, and for Category B firearms is $75 per firearm. What is the total annual license fee payable for this applicant? Option A, $125. Option B, $150. Option C, $175. Option D, $200. Correct answer is C, $175. Explanation. The review process indicates a need to assess the practical application of South Australian firearms licensing regulations, specifically concerning the calculation of license fees based on the number of firearms. This scenario is professionally challenging because it requires precise adherence to legislative fee structures and accurate record keeping to ensure compliance and prevent financial discrepancies. Misinterpreting the fee schedule or making calculation errors can lead to undercharging or overcharging license holders, both of which have regulatory and ethical implications. The best professional practice involves accurately calculating the total license fee by summing the individual fees for each firearm category held, as stipulated by the relevant South Australian legislation governing firearms licensing fees. This approach ensures that the correct amount is collected, aligning with the statutory requirements and maintaining the integrity of the licensing system. Specifically, the Firearms Act 2015 (SA) and associated regulations outline the fee structure, which is often tiered or based on the type and number of firearms. For instance, if the legislation specifies a base fee plus an additional fee per firearm, or different fees for different firearm classes, the licensee's records must reflect this detailed breakdown. An incorrect approach would be to apply a flat fee regardless of the number of firearms. This fails to comply with the legislative requirement for a fee structure that accounts for the quantity and potentially the type of firearms, leading to potential undercollection of revenue and noncompliance with the fee schedule. Another incorrect approach would be to estimate the fee based on a general understanding of the license type, without consulting the specific fee schedule for the current financial year. This introduces a high risk of error and deviates from the precise calculation mandated by law, potentially resulting in incorrect charges. A further incorrect approach would be to only charge for the most expensive firearm category held, assuming this covers all associated costs. This ignores the legislative intent to charge for each firearm or category as specified, leading to financial shortfalls and noncompliance. Professionals should adopt a decision-making framework that prioritizes consulting the most current legislative fee schedule, performing meticulous calculations based on the applicant's declared firearms, and maintaining clear, auditable records of all fee calculations. This ensures accuracy, compliance, and fairness in the licensing process.